So, dear followers, dear viewers, my today's guest is a professor of international law. He is also the director of the Peace Research Center at the Belarusian State University in Belarus and associated member of the Institute for International Law of Peace and Armed Conflict at Ruhr University in Bochum. She received her PhD in international law 20 years ago, and I feel a special connection to her not only because of the area of expertise in international law, but also because she has been dedicating her field of studies and work to a domain to which I also have my interest. Her legacy and work is already so rich that I will just leave you the link where you can check the huge impact her work has been having, not only for international law, but also for human rights. Presently, my guest is the United Nations Special Rapporteur on the negative impact of the unilateral coercive measures on the enjoyment of human rights and has been voicing her position on sanctions in many places around the world. Ladies and gentlemen, it's a tremendous honor for me that we have with us Professor Alina Douhan. Thank you so much, Professor Douhan, for accepting my invitation.
It's a pleasure. Good morning.
And now, starting with the questions that I have here for you. First place, we often hear about sanctions, coercive measures, restrictive measures. Do all these expressions mean the same, or they could be different between themselves?
In practice, unfortunately, that's one of the most complicated questions, as soon as the issue of terminology has not been settled yet at the international forum. My mandate naturally is focusing on unilateral coercive measures. At the same time, a number of reports which have been drafted, for example, by the UN Secretary General, or a number of statements done by the High Commissioner on Human Rights, are mostly focusing on economic sanctions. From the perspective of international law, it's necessary to admit that there is no precise definition of unilateral coercive measures, and there is no precise difference between the terminology, and that causes quite a lot of problems because people are using that different terms for their own purposes. But at the same time, it's logically, I focused one of my very first reports nearly 5 years ago on the terminological issues, and I tried to develop a definition of unilateral coercive measures. One of the main criteria which I set in the document is that when we are talking about unilateral sanctions, we cannot, from the very beginning, presume that they are definitely illegal. There are some types of unilateral pressure placed by states over another states, which is still legal. In particular, the so-called retortions. States may do unfriendly but legal actions. That basically means that states may decide not to cooperate with another states and to withdraw from an bilateral international treaty. That is unfriendly, but that is legal. At the same time, this withdrawal shall take place in the way which is prescribed by international law. So therefore, the withdrawal is not happening today for today. The withdrawal shall be happening in accordance with the Vienna Convention on the Law of International Treaties, with well in advance announcement about the willingness of withdrawal, which is under the Vienna Convention is, for example, 12 months. Or a state might decide to close diplomatic mission in another state, which is also unfriendly, but legal. Quite often in the media, it's qualified as unilateral sanctions, and that can be qualified like that, but it's definitely not unilateral coercive measures. Because from the perspective of international law and how I try to qualify it, unilateral coercive measures are measures which are illegal under international law, and therefore they cannot be taken by any state. Just to clarify the position until the very end, it's necessary to take into account that some measures can also be taken in the course of so-called countermeasures. That means in response to the previous violation of international law by the perpetrating states. At the same time, this possibility to take countermeasures is extremely limited. The criteria of countermeasures are very clearly qualified under the draft articles on responsibility of states for international wrongful actions. And the criteria are the following. So first of all, the measures can only be taken in response to the previous violation of international law. Therefore, it's necessary to identify what norm exactly has been violated. It can only be qualified by a victim, taken by a victim state, not just because we do not like the policy of another state, but because the violation of international legal norm has affected that state, namely. And even if we talk about collective obligations, which is even more complicated in international law, the criteria are extremely narrow. And additional elements which are important, the purpose of countermeasures cannot be punishment. The purpose of countermeasures is to restart fulfillment of international obligation. That means that therefore they are temporary, they are proportionate to the violation happened. And additionally, they cannot violate fundamental human rights. That is not fulfilled in the majority what is currently called unilateral sanctions, and therefore qualifies as unilateral coercive measures. I would refer, for example, to the recent decisions of the Court of Justice of the European Union, who explicitly said that it shall not even be attempted to assess whether the restrictive measures, sanctions of the European Union shall be qualified as unilateral, as countermeasures, because they definitely do not fit. And as a result, unfortunately, despite the fact that some unilateral means of pressure, let's call it unilateral sanctions, can still be retortions or can still be countermeasures, the majority of them, and I would say that we're talking about 98, 99% of unilateral sanctions taken, qualify as unilateral coercive measures as soon as they are illegal.
But so basically, you said about the concept of unilateral. What's basically the idea behind this unilaterality? And also at the same time, how can we set the threshold on this?
That is indeed also an easy question, because quite often, for example, sanctions of the European Union are thought to be presented as being multilateral rather than unilateral, taking into account that they are taken by all members of the European Union, and moreover, they are taken by the European Union as an international organization. At the same time, international law is currently based on the priority of the UN Security Council in the decision whether certain means of pressure can be taken and applied over states. And it's also important to take into account that the Charter of the United Nations is explicitly providing that the UN Security Council has a unique authority to decide on implementation and taking decisions about application of means of pressure, both non-military and military. Additionally, it shall be mentioned that in Chapter 8 of the Charter of the United Nations, even if the threat to the maintenance of international peace and security exists, even regional organizations cannot take any enforcement measures without authorization of the UN Security Council. Naturally, we all are very well aware about the prohibition to use force set forth in paragraph 4 of Article 2 of the Charter of the United Nations, as well as the principle of non-intervention to domestic affairs of states, and intervention in multiple resolutions of the UN General Assembly is qualified as taking place in different forms, including many non-military forms. So when we talk about the difference, I believe that the difference depends on existence of authorization of the UN Security Council. As soon as only the UN Security Council has the authority to decide about application of enforcement measures, then any measures which are taken without authorization of the UN Security Council, either they have been taken by one state, a group of states, or by a group of states acting via an international organizations, shall be qualified as unilateral.
All right. And basically, in the end, how can we describe what's the current legal status of coercive measures under international law? There are a lot of legal scholars suggesting different sources that may suggest the unlawfulness of such measures, but how can you define such legal status presently?
First of all, it's necessary to take into account that the scope of unilateral sanctions or unilateral coercive measures applied today is extremely diverse. They are not homogeneous, and therefore it's very hard to say, to provide just a general legal authority about the illegality. But in general, as I have mentioned, if we have a means of pressure applied by a state or a group of states without authorization of the UN Security Council or beyond authorization of the UN Security Council, and which is not in conformity with the international obligation, that qualifies as unilateral coercive measures, and they are illegal under international law.
So that's actually pretty important, especially because we have a main source, the United Nations Charter, and then also the United Nations bodies. And from there, we can start to evaluate and to examine each of those coercive measures. To what extent do you think that can sanctions be a violation of the customary and also the United Nations Charter enshrined principle of non-intervention? To what extent?
Well, from my perspective, I believe that the use of unilateral coercive measures is a clear example of intervention. Well, if we look at the Declaration on Principles of International Law and look at the definition of non-intervention and what exactly is prohibited under international law, we could clearly see that it speaks about all the same criteria. Measures shall be taken without authorization of the UN Security Council or beyond authorization of the UN Security Council, with the purpose to put a pressure over a state or to change a policy or behavior of another state, and it shall be taken in violation of international law. Mm-hmm. So basically, I need to mention that in order not to invent any new terminology, all these elements are applicable to the criteria of unilateral coercive measures, and therefore definitely, if we're talking about the unilateral coercive measures, but additionally about the means of the enforcement, they can be qualified as the intervention to the domestic affairs of states.
Mm-hmm. And after reading some legal scholars back from the 19th and the 20th centuries, we realized actually that back then the matter of sanctions was already being discussed in this same extent. Why hasn't this topic got much attention from both the League of Nations and the United Nations in order to regulate it and also establish an official legal framework that leaves no doubt about its application?
I believe that eventually there is no clear and simple response to your question. It's necessary to take into account the development of international relations at different historical periods. And additionally, it's necessary to take into account the complexities of international relations. Starting from the very beginning, we need to take into account that before the Charter of the United Nations has been adopted, there was not even a clear prohibition to use force. There were certain limitations. For example, the Hague Convention prohibited to use military force as a means of settlement of international disputes in 1907. Or, for example, Kellogg-Briand Act prohibited to use military force as a means of taking foreign debts. At the same time, states were allowed to use military force, although they were supposed to present valid grounds. So at the period when the use of military force has not been prohibited, it was very hard to expect that the application of non-military means of pressure will be prohibited. So basically, first of all, we need to say that before the Charter of the United Nations has been adopted and before the current principles of international law has been formulated, There was no prohibition to apply any types of means of pressure, including the military. After the Charter of the United Nations has been adopted, we need to take into account that it was adopted after the Second World War, which was extremely devastating with incredible human losses, and people were very scared about that. So their main focus was to stop interstate military conflicts. And other elements we consider to be less important at the moment. Even, for example, if we look at the Charter of the United Nations and we look at the terminology of the principle of non-intervention to domestic affairs of states, we will see that UN Charter doesn't prohibit states to intervene into domestic affairs of states. It prohibits United Nations to intervene into the domestic affairs of states. And only later on, and we are referring then to the documents adopted by the General Assembly in 1960, 1970, and later on, the principle of non-intervention has been formulated coming from the formulating customary norms of international law as a prohibition to intervene into domestic affairs of states by other states. In the period of Cold War, as you understand, the situation was very specific. We had two blocs which didn't cooperate much with each other and naturally which were not really open to regulate the issue of economic sanctions. And at that period, these two countries within that two blocs were cooperating mostly between each other. And the issue of the use of unilateral sanctions has not been considered to be so important. Although, for example, I would cite that already in 1967, if I'm not mistaken, the United States did a statement that economic measures applied by a group of Arab states against Israel was considered not to be legal and constituting an intervention to the domestic affairs of states, although the United States is not citing this case at the moment. And the United States is applying a lot of economic sanctions. After the end of the Cold War, we had a very specific situation. From one side, the UN Security Council was applying lots of sanctions. And unfortunately, as soon as there was no huge experience during the period of Cold War, the UN Security Council was applying sanctions in the extremely broad manner. They didn't identify framework, the authorization was extremely broad. And as a result, states were interpreting that authorization in the way they wanted. That's how the consequences of implementation of sanctions of the UN Security Council appeared to be so devastating. And I would refer, for example, to the well-known report about the impact of sanctions of the UN Security Council on Iraq. But unfortunately, the similar situation was absolutely the same in any other places. Therefore, states were using authorization of the UN Security Council for advancement of their own interests and behaving in the way they wanted. Additionally, at that period, states started to refer to inactivity of the UN Security Council and presented the so-called concept of humanitarian intervention, do something or do nothing doctrine, which, upon my opinion, first of all, has nothing to do with international law, and from the other perspective is extremely scary, taking into account that it's presenting the position of certain rules decided by certain states, which this imposition that we have the authority to do something because we believe that situation in a specific country is bad, is a clear violation not only of the principle of non-intervention, but in reality also of the principle of sovereign equality of states when one state intends to judge other states. And take into account that humanitarian intervention took place by all means, including the use of military force. The attention in the legal scholarship was mostly focusing on the possibility or impossibility to use military force when a state doesn't like the behavior of another state. Happily, this area So the application of this concept decreased a lot at the beginning of 2020s, but states started to use other means, trying to insist that the use of non-military means doesn't fall within the criteria of the prohibition to use force, and therefore it's allowed. There are lots of academic works insisting that the use of non-military means is not prohibited by international law, but eventually I believe that it's very hard to dispute the very simple fact. International law is based on the principle pacta sunt servanda. Obligations shall be respected. States cannot refer even to the provision of their domestic law, and in the case of the European Union, for example, to the provisions of their regional regulation as a ground of not fulfillment of their international obligation. And that's what exactly is happening. And unilateral coercive measures applied today violate an extremely broad scope of international legal obligations. And additionally, they violate a broad scope of international human rights norms.
I would also like to highlight, for example, the case on Nicaragua by the International Court of Justice, where the judges basically start to focus their assessment on the economic coercive measures, but then they suddenly quit. In my opinion, it was a lost opportunity by the court to at least have a say on this matter, even though it was a slight view, but it could be a great opportunity to start a discussion. And basically, as some scholars like Johan Galtung, when studying the topic of sanctions, they used to set the difference between what is considered to be a punishment-oriented attitude and compliance without punishment. Do you think that most of the unilateral coercive measures adopted by the central governments, they basically seek punishment as the main goal instead of trying other methods aimed at preventing tensions and capitulation?
I need to say that I disagree with the very discussion of this question. I believe that from the perspective of international law, and for example, when we are based on the very basic principles of interpretation, we need to interpret terms in the most direct way, unless the specific meaning is given to the terms. From the perspective of international law, it is not allowed to violate international obligations. If you violate international obligations, whatever good purpose you can cite, it doesn't matter. You still violate international obligations and it's illegal. You cannot do it. States cannot punish each other, take into account that under the principle of sovereign equality of states, states are equal, and therefore none of them has either jurisdiction or authority over another state. When it comes to the punishment of businesses or companies, we have clear-cut criteria of criminal law. If there is a case of a criminal delict committed or a crime being committed, if a state has jurisdiction, it shall start investigation. If a state doesn't have jurisdiction and it starts an investigation without any ground against a citizen of another state, it intervenes into the jurisdiction of that state, because that is that state which has the authority to start a criminal case. So therefore, again, I would come back to the definition of the intervention and what is prohibited by the principle of intervention. Intervention is seeking to apply means of pressure. We are the punishment, or we are putting a pressure by other means to change the policy or behavior of a state or to comply with the requirements of another state. But all that is an intervention. It's prohibited by international law. And therefore, it's not possible to justify the application of unilateral coercive measures by use of any other means and by use of any even higher purpose, which is quite often cited, that states imposing unilateral sanctions and sees that they pursue some type of higher goals.
All right. And having in mind the principle of sovereign equality, and as well as other customary principles, how can states force other states to abide with the review of what international law should be? In a friendly way, of course.
One of the principles of international law is a principle of peaceful settlement of international disputes. If states do not like the behavior of another states, the very first step is negotiations, not the threats, but negotiations based on the principle of sovereign equality. Other measures shall be taken based on the principle of cooperation between states. And therefore, if states just decide that they apply sanctions or they apply, let's call it maximum pressure campaigns, it's neither cooperation nor the way to look for the peaceful settlement of international disputes. If states want to establish or develop new rules of international law, the process is rather simple. Either it's a customary international law, which is created during the long period of time where the repeated practice will be well recognized by states, or it's an international treaty. The process of negotiating international treaty is not fast, but nevertheless, it's a possibility to set forth the specific legal norms in there. No other mechanism exists.
Mm-hmm. And some countries deal with sanctions as part of criminal law approach, while others do that as public law, and some others choose an hybrid way. What can we take from all these experiences?
I'm afraid that the reference to unilateral sanctions from the perspective of criminal, administrative, or any other areas of law is also misleading. And additionally, we need to take into account that we're talking today about primary sanctions and the means of enforcement of primary sanctions, which is currently frequently going via the criminal law mechanism. Traditionally, and I started to participate in the discussion about the use of unilateral sanctions within the Human Rights Council starting from 2013. Initially, the European Union, as well as some other sanction states, were insisting that sanctions do not constitute a criminal penalty. And that is the ground why they do not apply the due process and fair trial standards, because this due process, upon their opinion, shall only be applicable to criminal law. They were insisting that it's an administrative public law process, and therefore they can decide on imposition of sanctions without any due process standards, and the authority as concerned the jurisdiction might be much broader. At the same time, I have to say that even this approach doesn't justify the application of unilateral sanctions or unilateral coercive measures as soon as, first of all, when states decide on imposition of unilateral sanction, they do not have jurisdiction over businesses or individuals of third states when we are talking about targeted sanctions. And when we're talking about sectoral sanctions or sanctions against specific states, it clearly violates international obligations. Secondary, even when we are talking about the use of public law processes, we shall take into account that under public law, it's a state which still shall prove that an individual or a company has violated the law. What we're facing today, unfortunately, is fully vice versa. The sanctions are decided extremely easy. Information is not disclosed. A person quite often doesn't know that he or she is designated, and this person shall prove that he or she didn't commit anything without knowing what was the ground for their designation. And it's very hard to prove that they didn't do anything bad if you do not even know what is the accusation. Therefore, from the perspective of national law, the process of the decision on imposition of unilateral sanctions is also illegal. However, today we also need to take into account the new tendency, which I believe is extremely dangerous, and the tendency demonstrates the expansion of practice of enforcement of unilateral sanctions regime via different means, starting from imposition of secondary sanctions for circumvention, alleged circumvention, or assistance in circumvention of unilateral sanctions regimes, imposition of criminal penalties, civil penalties, administrative customs penalties. And these penalties are quite often extremely high. I have to mention that, for example, even the European Union has adopted in April 2024 a regulation on the criminalization of sanctions circumvention, which provides for at least 5 years imprisonment for circumvention of sanctions regime. And here we face, even upon my opinion, from legal perspective, even more ridiculous situation. Naturally, from one state side, a state is free to decide on what it constitutes to be a crime under the domestic law. But from the other side, the criminalization of sanctions circumvention basically means the following. If, as the same states insist, the primary sanctions are imposed for something what is not a crime, and therefore the due process guarantee shall not be used, and the burden of proof is extremely low, how could circumvention or assistance of circumvention of primary sanctions for something what is not a crime be a crime? So basically the perpetrator of the first alleged violation is punished more than the initial perpetrator, even if there was a perpetrator. And additionally, in these criminal cases, people also do not know what are the grounds. They have no possibility to appeal. The appeal processes, I call them appeal processes, but basically the possibility to protect themselves is very vague. And what is unfortunately, this mechanism is very non-transparent. You do not have clear-cut statistics in any states. You might only see single cases. At the same time, what we are currently observing that this criminal charges process is very actively used, and quite often might result also in extradition. I would remind, for example, about the case when a Bulgarian nation has been arrested by Greek authorities for alleged circumvention of the United States, not even the European Union, United States sanctions regime against Russia. And Greece extradited the Bulgarian national to the United States under this criminal law charge of circumvention of the US sanctions regime without some consent of Bulgaria. That basically undermines the authority of Bulgaria and undermines the sovereignty of Bulgaria in this specific case. Upon my knowledge, the European Parliament sent a request for clarification to the European Council. However, I didn't find any final decision at the moment.
Let me also tell you that and share with you my experience also as a lawyer, and especially representing people facing criminal liability because of circumvention of sanctions, that one of the huge challenges that we have here is to try to set the scope about what's considered to be the sphere of interests of the sanctioned person. It's really hard to fight against that, especially here in the European Union and on any member state. And that's been very challenging, not only for me, but also for everyone dealing with the matter of coercive measures. Another question is, what's your intake on we spoke about the primary coercive measures, but what about the secondary coercive measures, as well as the extraterritoriality of unilateral sanctions? As you know, in the European Union, there is a legal framework for the extraterritoriality of unilateral sanctions and also for secondary coercive measures in order to avoid the application of coercive measures imposed and adopted by the United States.
Well, I believe that unfortunately, the majority of that exists in paper only when we talk about the protection. As I have already mentioned, sanctioning states are currently using secondary sanctions, criminal, civil, customs, penalties for circumvention of sanctions regime broader and broader today. And standards of due process are not respected in that cases. I dealt with lots of individuals and companies which have been facing either charges or being subjected to secondary sanctions for circumvention of sanctions regime. And the story the telling is nearly always the same. They do not know clear accusation. They are not aware of the grounds. They do not understand what documents shall be provided. The process is extremely lengthy, and the standards of the burden of proof from the side of the states are extremely low. So quite often, when we're talking about the companies, only the hugest companies decide to engage in that process because the smaller companies understand that the chance of success is extremely low and they are not able to cover the expenses of bringing case to the court or any other institutions are trying to appeal the case. So-called blocking statutes, which are adopted in many states, they do exist in practice, but in reality, I see that they are still need to have serious improvement. The European Union blocking statutes has been adopted after the European Union tried to start a case at the WTO in 1997 to protect the businesses of the European Union from the jurisdiction of the United States. We need to start from the point, first of all, that there is no notion of extraterritorial jurisdiction. The ground in international law. So the grounds of the existence of jurisdiction of states are very clear. It's personal jurisdiction or territorial jurisdiction. And therefore, if a state believes that it can start a criminal or any other case, there shall be valid grounds to demonstrate that interests of state or the nationals of states or businesses of states are directly violated. However, I need to mention that even if it's the case, states quite often prefer to use unilateral sanctions rather than to start a criminal case. In one of my reports, I referred, for example, to the case of 6 Nigerian nationals designated by the United States and accused in committing cyber fraud against nationals and companies of the United States. But the United States didn't even take an attempt to start a criminal case. If indeed these individuals have committed a cyber fraud against the US nationals and companies, the US has grounds and has jurisdiction to start a criminal case. But for criminal case, the burden of proof is high, standards of due process are clear, and therefore, upon my understanding, there was no possibility to do a criminal case because the US didn't have evidences that indeed there was a case of cyber fraud. Therefore, they decided to use these simpler means upon their opinion and to impose unilateral sanctions, preventing people from any possibility to protect themselves. And the use of these sanctions is not legal. Although, for example, if the criminal case would be started, it would be legal. When we talk about the blocking statutes, I would refer not only to the European Union, but attempts to develop counter-sanctions legislation in the countries which are under sanctions, they basically partially follow the same way. The idea is that the nationals and companies acting on their territory are not supposed to implement unilateral sanctions or not supposed to comply with unilateral sanctions from the side of third states. And from one state, these counter-sanctions legislation and blocking statutes, they provide for penalties for companies and people which complies with third country sanctions, but at the same time, it's possible to get a permission to comply if serious business interests are affected. And this mechanism, upon my opinion, is very dangerous, and it endangers not only people who are affected due to all this strange system, when, for example, even the monopolist producers of specific medicine refuse to sell medicine to the countries under unilateral sanctions due to the fear of penalties for possible circumvention of sanctions regime. But it's dangerous for the companies themselves and for the population of countries which enforce third country sanctions. So what I'm currently facing, when I deal with the companies in the European Union, I observe that everyone tries to shift jurisdiction to shift responsibility to someone else. So let's give me a simple example. I dealt with a number of cases of so-called butterfly children. So people suffering from epidermis bullosa, a very painful genetic disease when the skin is extremely sensitive. I dealt with this case as concerned the patients in Iran, patients in Belarus. However, the same situation exists as regards other countries under sanctions. There is a monopolist producer of bandages which can be used by these patients, and this monopolist producer used to sell these bandages to all around the world. And take into account that percent of people suffering from this disease is extremely low, there has never been an attempt to have another producer. So the alternative is either these people will get these bandages they used to get for all their life, or they will live in terrible pain when after every time they change the bandages they use, it's taken away together with their skin.
Mhm.
What I did a letter to the company, to the United States, to the European Union, and to Sweden, in which the company is based. And the United States responded that basically there are humanitarian exceptions. It's not our fault. The company didn't respond, but I know that how they usually respond. They say that we have no protection. And even if we are ready to sell the bandages, we are not allowed to receive money, for example, from Iran. If we sell bandages and Iran pays, we will be subjected to sanctions of the United States, not European Union, of the United States, for circumvention of sanctions regime, and European Union will not protect us against that. The European Union referred to humanitarian exceptions, and Sweden, and I need to say that Sweden was very open for cooperation, and once it even paid the year storage of bandages to be delivered to Iran as soon as the situation is really dramatic. So for these people, the life turns to every day, every second torture. So therefore, what's happening, the Sweden is, as a country member of the European Union, cannot alone resist the situation and cannot protect its own business. So, and as a result, the European Union and the United States refers to the business decision, freedom of business decision of the company not to sell to the countries under sanctions. But in reality, it's not the business decision. It's the fear of the company to be subjected to incredibly higher penalties and might be to get bankrupt or to lose markets of the countries which impose sanctions. So as a result, there is no freedom of business decision in this specific case. Businesses do not have any protection from the side of their states or from the side of the European Union. And the United States sanctions penalties for circumvention of sanctions of which can be applicable in this specific case says that it has nothing to do because there are humanitarian exceptions. And it's necessary to say that humanitarian exceptions is a very specific case which is not clear whether it exists or not. They exist on paper, but in reality, it's very hard to implement the humanitarian exceptions. Recently, I finalized the development of the guiding principles on sanctions, business, and human rights, and several paragraphs there are directly focusing on delivery of humanitarian assistance. And there I identified a number of challenges faced in the delivery of humanitarian assistance, including the very simple ones. Even if a company agrees to risk and to sell the medicine, you cannot pay, or a company will be punished for accepting your payment. Companies might be subjected to punishment if for delivery, therefore no one takes this cargo, and companies may be subjected to punishment for insuring the cargo, and therefore the companies which produce medical goods, even with the existence of licenses, quite often ask three basic questions: how you will pay, how you will deliver, and how you will insure. And quite often there is no solution for that cases. Therefore, I believe that blocking statute is definitely not enough. Again, I'm referring to the guiding principles I developed and the commentary to the guiding principles. There, I did a few proposals on the point. So first of all, I underlined that in accordance with the principle of due diligence, a state is obliged to make sure that businesses under the jurisdiction and control do not violate fundamental human rights. And that means not only that they shall threaten the business to punish it if it circumvents someone's sanctions regime. It shall also protect their own business, because the obligation of due diligence includes all possible means, legislative, administrative, which include also as punishment, but also a protection. If a business have no other choice, otherwise it gets bankrupt or it will face criminal or any other types of punishments.
I have one last question for you. I mean, it's a two-in-one. First, having in mind that example that you just shared with us, that case, I want to ask you first, do you believe that coercive measures are sufficiently scrutinized by the people, by the public, along with international organizations outside of the scope of the countries or organizations that adopt coercive measures? And then, do you think that sanctions imposed by the Western Bloc against not only the Russian Federation under the framework of the Ukrainian conflict, but also against Syria and against Venezuela, for example, cases that you know way to the deep of its extent, do you think that they are basically respecting the lawfulness of the international law framework?
Well, I believe that it's possible to do the whole course in response to your last question, but I will try to be brief. When we're talking about the first part of your question concerning the scrutiny of unilateral sanctions, I believe we need to address it from two perspectives. The first perspective is about what measures are imposed. And eventually, it's necessary to admit that it's not even clear what measures exactly are imposed if we are talking not about primary sanctions only, but the means of sanctions enforcement. I have already mentioned that, for example, there is no transparency in the sphere of criminal law. Similar situation exists in customs and exists in civil law. So therefore, no one is ever sure what sanctions exist. And no one is ever sure what limitations are imposed by sanctions, because we also need to take into account that existence of sanctions is one thing, but the application of sanctions is usually much broader, because beside the sanction regulation, there are usually a number of non-binding acts, which are not even legal acts, which have strange names, like questions and answers, or frequently asked questions, or guidances, or instructions, which have theoretically no legal status in the domestic system, but which expand incredibly application of unilateral sanctions. And unfortunately, when the case comes to the court, they are interpreted as being binding by the courts. We'll give, as soon as you have mentioned Russian Federation, I will give a very simple example. States which impose sanctions, they usually insist that they use mostly targeted sanctions, which affect only the bad person, allegedly, and they do not affect anyone else. But let me give you a very specific example. Western countries have imposed sanctions against many high state officials, including presidents of countries. And they imposed sanctions on the president of Russian Federation, Vladimir Putin. There are two decisions by the UK courts. In the first decision, one of UK courts said that UK believes that Russian Federation has a centralized economy, and therefore everything what is happening on the territory of Russian Federation, as well as anyone living or having nationality of Russian Federation, is under the direct control of Russian president. And therefore, dealing with anyone on the territory of Russia, having any nexus to Russia, or having Russian nationality shall be interpreted as circumventing sanctions regime against President of Russian Federation. The second court decision is a bit more nuanced. It said that no, it's not possible to say that everything in Russia or having any nexus to Russia or having Russian citizenship shall be considered as being under direct control of the Russian president. It shall be assessed in every specific case, but with due account of geopolitical interests. From the perspective of law, it's nothing. From the perspective of law, it basically means that if the country which imposes sanctions believes it to be necessary, it will interpret it still to be a circumvention of sanctions regime against the president of Russian Federation. Therefore, today it's very hard to judge what is the scope of unilateral sanctions. The second part of response to your question is about the impacts of unilateral sanctions. What I'm currently trying to do, I try to establish a monitoring tool of humanitarian impact of unilateral sanctions. I already work on that for nearly 2 years. And I need to say that it's an extremely complicated task. As soon as naturally not all data or not all situation on the territory of a state affected by sanctions is due to sanctions only. There might be different other criteria. And for me, the task is to identify at least what are the causality links and what are the reasons for example, of deterioration of humanitarian impacts, to include some specific factual cases. The process is ongoing. I'm still very open for everyone, to invite everyone to fill the form and to submit information. But let's tell the truth. Being one expert, it's definitely not enough to do all this monitoring work. And at the moment, no one else is doing that. So we do our best. I hope that by the moment when I finish my mandate in June 2026, we will have a functioning mechanism, and I hope that it will be developed further. But at the moment, not a single body, no one else within the UN, no one else within the UN specialized agency is doing these calculation, statistics, monitoring, and assessment. Responding the second part of your question, I need to mention that situation is extremely complicated. As I have already mentioned, we cannot judge, say that all sanctions violate this specific norm. We need to address every specific case, and we need to address it from the perspective of various areas of international law. In particular, let me give you an example. If we talk about human rights affected by unilateral sanctions, we definitely talk about the law of human rights. At the same time, when we move to the area of delivery of humanitarian assistance, we will have to address the customary norms developed within the United Nations about the principles of delivery of humanitarian assistance, like, for example, the standards of impartiality, neutrality, and so forth. When we talk about sanctions imposed on international civil aviation, we can address that from various perspectives, starting from one side to the violation of the freedom of movement for people, which is definitely affected, but from the other side to the violation of security standards developed by International Civil Aviation Organization. And I'm not talking only about the security in the case of unlawful intervention in the functioning of civil aviation. I'm talking about very simple elements, for example, the maintenance of the planes, when it's not possible either to do a reparation abroad or to procure and to deliver spare parts in the country. I'm talking about the additional emission of engines, taking into account that due to unilateral sanctions, planes of countries under sanctions are quite often prevented to be refueled abroad, and therefore they have to fly with the double weight of fuel to be able to fly to and back, and that means an additional weight and additional emission. It means that even in the case of emergency, the plane will not be repaired abroad. And moreover, we also face situation of, for example, training of pilots, because the standards of training provide for the access to international databases, to possibility of access to online courses, to travel abroad, to get training within International Civil Aviation Organization or regional offices. And therefore, the qualification of pilots might drop as well. If I talk, for example, about other areas like freezing assets, here we might face the whole scope of areas of international law, starting from human rights law. I receive number of complaints that, for example, the assets of individuals have been frozen and they cannot unfreeze it even for urgent medical purposes, and therefore their right to health and sometimes even right to life is affected. But also we are talking about the investment agreement, investment protection agreements, which are violated. We might talk, if it comes to freezing assets of central banks, we come to the immunities of states and state property. We come to the access to justice as soon as the adjudication process is also affected. Therefore, when I'm asked about the impact and the place of unilateral sanctions in international law, I'm usually saying that it's easier to name the areas of international law which are not affected by the use of unilateral sanctions rather than those which are affected, nearly all of them. Therefore, I believe that there is still a huge way forward for lawyers, because the international law is pretty clear on many of the issues. And therefore, I believe that the scholars, as well as legal professionals, shall play an important role in the area when they are researching, they are publishing. What I also observe, for example, are very high challenges faced by scholars in doing the research, because at the moment it's very unwelcome to do the research. I plan to do a report to the UN General Assembly this year, focusing on the impact of unilateral sanctions on the right to education and academic freedom. But I have already received multiple reports about penalties faced by scholars coming from the countries which impose sanctions just for addressing this issue, or some of them are even advised not to talk to me. Because even confidentially, because that might be dangerous. Some of them are advised not to participate in the conferences with people coming from countries under sanctions. The academic publications are not accepted even for peer review, with reference that you are coming to the new sanctions policies in publication agreements. And that, I believe, undermines not only rights of those who appear to be directly affected. It undermines the development of research, and it undermines the development of scholarly knowledge that at the very end affect the whole world.
Thank you so much, Professor Doğan, especially for dedicating a huge part of your time to answering to my questions, and also to clarify specific and very important aspects of coercive measures. Thank you so much for this.
It was a pleasure.